Almighty God, we give thanks to you, the creator of the universe, and humbly beseech you to direct and prosper the deliberations of the members of this house here assembled for the advancement of your glory and the trust and welfare of the people of Trinidad and Tobago. Grant that peace and happiness, truth and justice may be established among us for all generations. Amen. Amen. Namaste.
Announcements by the Speaker.
Honorable members, I have received communication from Mr. Rushton Parry, MP, member for Miaro, who has requested leave of absence for the period October 13th to 25th, 2021, and Mr. Esmond Ford, MP, member for Tunapuna, who has requested leave of absence from today's sitting. The leave which the members seek is granted. Honorable members, it was not my intention to address you at the beginning of today's proceedings. However, I am in receipt of correspondence under the hand of the Leader of the Opposition and Member for Superior, the Honorable Kamla Prasad Bisesa, SC, MP, raising several issues which I am compelled to address. It is my hope that by addressing honorable members collectively, any and all misapprehensions, misconceptions, and misconstructions will be dispelled. The Leader of the Opposition has raised, by my assessment,
Madam
three
Speaker,
matters.
Order paper, are you addressing?
The Leader of the Opposition has raised, by my assessment, three matters. Firstly, whether a debate ensues when a motion pursuant to Section 36 of the Constitution is proposed, and if so, at what stage? Honorable members, I believe what we are about to embark upon today is considered by all of us and the citizens of our nation to be extremely important. So I wish that we proceed. The Leader of the Opposition has raised, by my assessment, well, member, if you can have a, can you, so that if I'm asked a question because a matter is raised, then the member knows that he should sit so that I can respond. For all members who are not aware, I believe we are under the item of business, announcements by the speakers. The Leader of the Opposition has raised, by my assessment, three matters. The Leader of the Opposition has raised, by my assessment, three matters.
Madam Speaker, I feel
So members, again, I say that this is important business, and I expect that we are all very anxious to get on with the business for which we assemble here. So we proceed.
In due process.
Okay, so member for Coover South, I believe you've acted many times as Chief Whip, and for all members, even the new ones, we are quite aware that under the item announcements by the Speaker has made announcements and rulings of all nature. We've done that repeatedly. So I again invite you all to adopt the proper posture so that we can proceed with the business for which we are summoned here. The Leader of the Opposition has raised, by my assessment, 3 matters. Firstly, whether a debate ensues when a motion pursuant to Section 36 of the Constitution is proposed, and if so, at what stage and by which body. Secondly, an assertion that guidelines issued by the Speaker in relation to these proceedings are ultra-vires the Constitution. And thirdly, accusations of bias leveled against this chair and a member of the other place. By now, we are all familiar with the provisions of Section 36 of the Constitution. It is, after all, the reason we are assembled. However, I shall take this opportunity to remind honorable members of its provisions. Section 36, subsection 1. The President shall be removed from office where a motion that his removal from office should be investigated by a tribunal is proposed in the House of Representatives. B, the motion states with full particulars the grounds on which his removal from office is proposed and is signed by not less than 1/3 of the total membership of the House of Representatives. C, the motion is adopted by the vote of not less than 2/3 of the total membership of the Senate and the House of Representatives assembled together. D, a tribunal consisting of the Chief Justice and 4 other judges appointed by him, being as far as practicable the most senior judges, investigate the complaint and report on the facts to the House of Representatives. E, the Senate and the House of Representatives assembled together on the summons of the Speaker, consider the report and by resolution supported by the votes of not less than 2/3 of the total membership of the Senate.
Inquiring whether the
Member for Daparima, I think this is your second term, so that you are well familiar with the standing orders and parliamentary practice and procedure. Therefore, I take it that you know the procedure. I shall now treat with 3 matters referred to earlier in turn. Whether a debate ensues when a motion pursuant to Section 36 of the Constitution is proposed, and if so, at what stage and by which body. A motion is defined as a proposal brought before the House for a decision. In general, Motions are indeed debatable and can be amended. However, there are several exceptions, and I am certain that the most seasoned parliamentarians, including the Honorable Leader of the Opposition, are familiar with them. By way of example, a privilege motion does not trigger a debate. It is a proposal that an investigation is warranted. It is purely procedural. A privilege motion is never debated because it is an originating procedural motion. It is simply a complaint accompanied by grounds upon which the complaint is based.
Madam Speaker, are you...
Member for Barataria San Juan, again I remind you and all members that we are under the item announcements. By way of example, a privilege motion does not trigger debate. It is a proposal that an investigation is warranted. It is purely procedural. A privilege motion is never debated because it's an originating procedural motion. It is simply a complaint accompanied by grounds upon which the complaint is based. If, in the opinion of the Speaker, the grounds have established a prima facie case, then the privilege motion is, without more, referred to the relevant committee for investigation and report. It is only subsequent to the report of the investigating committee to the House that a debate takes place on the committee's findings and recommendations. Therefore, it is well-established parliamentary practice and procedure that the term...
Madam Speaker,
I'm forced to again ask you, is this a substantive motion before us, or from a procedural point of view, a constitutional issue that we are dealing with here today?
and
Based on the length of your statement here this morning, will the member for Siparia be allowed to respond to
we
the Parliament and democracy of this country?
Again, I remind members, this is announcements. The business we've been summoned here for, according to the member of Couva South, as he well knows, invokes Section 36 of the Constitution. It is on the order paper, and we shall get to it. Therefore, it is well-established parliamentary practice and procedure that the term motion does not always mean that a debate is automatically initiated. The determination of whether or not a motion proposed under Section 36(1)(a) is debatable can easily be gleaned upon a careful examination of the Constitution. We all know that the first rule of statutory interpretation is the literal approach, and the language used by the framers is very instructive. It is clear, based on the language used in Section 36 of the Constitution, that this process has 4 distinct procedural steps.
Madam Speaker.
Constitutional freedom of speech. This is a matter which has been raised by in writing, properly so by the
Why are our mics being shut off?
We should have
Yes, shut it off.
responded to in writing, Madam Speaker.
Member for Chaguanas West, this is an announcement. All right? And if it is that members are intent on delaying the process of us getting to the substantive business, then we will just have to take the time that is required. I shall proceed.
Madam Speaker, respectfully, we have a delay. We are seeking clarification.
And I believe all the clarification that has been sought has been addressed. It is clear, based on the language used in Section 36 of the Constitution, that this process has 4 distinct procedural steps. 1, the signed motion is proposed. 2, the motion must then be adopted. 3, a tribunal will investigate. And 4, the report of this tribunal is considered.
I want to speak. I'm being cut off. Is this an attempt to silence the free flow of information?
Honorable Member for Naparima, I really can't understand the difficulty that you are having. Honorable members, I have been advised, and it is also my considered view, that the very first stage of this process, that is, the proposal of the motion,
of our democracy, that the minority will have its say. So we are asking for a right to respond to this announcement, please.
it appears that the members of the opposition are not prepared for us to proceed at this time, and I think maybe if we suspend for about 15 minutes, we'll all get back here to the serious business of this House. This House is now suspended.
You are now delaying the process.
Continue with your announcement.
We are under a dictatorship under the
Honorable members, I have been advised, and it is also my considered view, that the very first stage of this process, that is the proposal of the motion, is purely originating and procedural. The motion with A, full particulars, and B, the required signatures appended, is proposed to the House. This is done by the proposer reading the motion into the records of the House, similar to the reading of a privilege motion. At this stage, the Constitution does not provide expressly or by implication for a debate. Thereafter, the motion progresses through the other three stages. The process as set out in the Constitution is pellucid. The next stage is the vote to adopt the motion as proposed in the House of Representatives. This conveys the unequivocal intention of the framers of the Constitution. To seek to compare this motion with a Standing Order 41 motion is misguided. A Standing Order 41 motion, which initiates a debate, is decided by a majority vote in the House. The procedural motion in Section 36 of the Constitution requires only the signatures of at least 1/3 of the membership of the House to advance to the next stage. Surely, the Honorable Leader of the Opposition is not suggesting that the Speaker of the House insert words into the Constitution that are not there. The Leader of the Opposition's letter
no one compares.
also seems to suggest that the debate she desires
This is a constitutional motion. No one under the Constitution is supreme law.
Okay, so honorable members, the Honorable Member for Superior has written to me a letter, which you all are aware of. It's been circulated in the traditional and social media. And this is an opportunity to set the record straight for all members and the listening public to get an appreciation of what has guided this process.
Madam
Okay.
Speaker, you must allow a full debate.
Madam Speaker, is the member for Superior being allowed to reply? Since you are replying a formal letter, will the member of Superior be allowed to reply?
Honorable members, and particularly the more seasoned members, are well aware that under the item announcements, a speaker has given rulings, a speaker has responded to correspondences from members. In fact, had this been just a one-on-one, the learnings from such a very novel procedure which we are about to embark upon would never be shared by not just us in this chamber, but to the general public who have equally a vested interest in what we are to embark upon. So again, I beseech members of this chamber to allow the announcement to continue and finish so that we can embark upon the other business on the order paper.
Madam Speaker, with due respect, is the Honourable Speaker aware that under this extraordinary sitting, that no other business is to be conducted? No other business.
And I am so aware, but we also know prayers and announcements are ordinary business that is allowed under an extraordinary sitting. Okay, so we shall proceed. The Leader of the Opposition's letter also seems to suggest that the debate she desires should take place in the Electoral College. Indeed, The member asserted that, and I quote, "It is absurd to ask the members of the House and Senate to vote on such an important motion without a debate," end quote. However, it is strikingly odd that the leader of the opposition would refer to a clear provision of the Constitution as absurd. All of us assembled here swore an oath to uphold the Constitution, the very Constitution that the member is now labeling as absurd because it is at variance with her misguided opinion. The Honorable Leader of the Opposition...
Madam Speaker,
the Honorable Leader of the Opposition...
Respect to you, Madam Speaker, and to 48.6, improper motive being imputed against a member of the...
I overrule. It doesn't arise in this circumstance, and therefore we continue. The Honorable Leader of the Opposition...
Can I just have one
is certainly free...
please, Madam? Is it in the announcement stage, anything can be said about any...
Member for Caroni Central, we are all guided by the standing orders with respect to what is allowed and what is not allowed. And as you know, the House allows for robust discussion. The Honorable Leader...
one-way discussion.
The Honorable Leader of the Opposition is certainly free to hold such a view, but this position is contrary to the provisions of the Constitution. Section 36(1)(c) does not contemplate a debate by the Electoral College at this stage. Section 36(1)(b) identifies the motion as a document containing the full particulars and the grounds on which the complaint is based, together with the requisite signatures. It was for the Honorable Leader of the Opposition to ensure that her document contained sufficient details, that is to say, full particulars, to assist the Electoral College in determining whether her complaint warrants an investigation by a tribunal. Interestingly, honorable members, the Constitution provides that upon receipt of the report of the tribunal headed by the Chief Justice, the Electoral College, on the summons of the Speaker, considers the report. Honorable members are asked to note the clear distinction in the wording of Section 36(1)(e) of the Constitution. It is at this stage that the Constitution provides for a debate to take place by the Electoral College. Admittedly, a motion to trigger the removal of a president is rarely invoked. In fact, the framers of the Constitution intended that when the provision is invoked, the complaint and the particulars must be sufficiently so weighty that it would be likely to succeed. This is evident from paragraphs 162 and 163 of the Wooden Commission. Paragraph 162 states as follows, and I quote, "We thought it necessary to make provision for removing the president from office, although it is expected that this eventuality will arise." arise. It continues at paragraph 163, and I quote, "The recommended procedure for his removal, as set out in the attached draft Constitution, is designed basically to make it unlikely that the procedure will be set in motion unless there is near certainty of the likelihood of its succeeding," end quote. Guidelines issued in relation to these proceedings are ultra vires, which is the second matter raised. I trust that all members now appreciate that as Speaker of the House, I am heavily guided by the Constitution of the Republic of Trinidad and Tobago for the purposes of this procedure. It is the Constitution itself that authorizes the making of guidelines by the person who sits in this chair. In this regard, members are directed to Regulations 3 and 23 of the Electoral College Regulations, which are made pursuant to Section 28, subsection 4 of the Constitution of the Republic of Trinidad and Tobago.
Madam Speaker, are you saying that the 36C is a meeting of the Electoral College, please?
It is not. This is not.
Honorable members, I really consider that this is very important, not just for members of the chamber, but also for members of the national community, for them to be apprised of the reasoning and that guided the procedure that I have laid out. And therefore, again, I ask members to kindly listen in silence and allow the announcement
Madam Speaker,
to be made.
Madam Speaker, I am...
The legal advisors that have advised on this presentation.
And I'd say to the member for Oropouche East, again, if maybe one allows the announcement to continue to its end, those questions will be answered to your satisfaction.
Madam Speaker, is this 36C? Is your legal advice indicating that this is a meeting of the Electoral College, please? I seek clarification of that, please.
And member for Caroni Central, I think, again, if you listen carefully, the announcement is structured to give you the guidance and the clarification you seek with respect to the stages. I assure members that in this matter, quite extensive and substantial research has been undertaken by the very experts who have competently guided this chair long before I became its occupant. These experts are in fact the principal advisors on practice and procedure in this part of the Commonwealth. Their research was quite helpful to me, and they directed me to constitutions of Nigeria, Kenya, and several other Commonwealth jurisdictions which utilize similar constitutional language in relation to provisions for the removal of a president. This research, along with the provisions of our Republican Constitution, form the basis of the guidelines for today's proceedings. Accusations of bias. Honorable members, I must express that I'm astounded by the claims of bias made by the Honorable Leader of the Opposition, and even further perplexed by the factors submitted in support of same. I am of the opinion that these issues do not arise. It is absurd to suggest that any or every person who has participated in processes that are not the specific subject of this motion should be disqualified from participating in these proceedings. Many honorable members here have sat in cabinet, have held or currently hold ministerial portfolios, have participated in debates, have asked questions, and filed motions on issues which may be perceived as related, although irrelevant, to this matter. The claim of the Honorable Leader of the Opposition, taken to its logical conclusion, would suggest that even the proposer and the members who signed in support may be perceived as biased and should be disallowed from participating as well. No right-thinking person will see the remotest connection between that 2009 order and the subject matter of the motion at hand. The assertion is absolutely illogical, and I reject it outright.
Madam, looking for justification for why you are not recusing yourself.
Member for Princestown, again, as I've said, A letter was written by the honorable member. It has been widely circulated, and a lot of opinion has been in the public domain raised concerning this. This is the opportunity to advise the members of this House and the members of the public of my response.
Madam Speaker, with the greatest of respect, in fact, you are emphasizing the reasons we should have a debate on the motion to further explain all those things in the letter.
And member, again, for St. Augustine, having heard you, the reasons for the guidelines are being explained here under announcements to dispel all your misconceptions.
Madam Speaker, you are making determinations without providing any substantiation for your decisions. Madam Speaker, is it your intention to recuse yourself, or are you justifying why you should not be recused? Because the leader of the opposition...
Member, and again, as I've said to all members, if they would allow the announcement to be made, all the matters upon which they seek clarification by intervening would be given. The assertion is absolutely illogical, and I reject it outright. I am obliged to resist the urgings of the Honourable Leader of Opposition that I seek to influence or advise or convince any Member of Parliament to refrain from participating in this process, as to do so would be a travesty of the very democratic principles which the member purports to advance.
Madam Speaker,
to acquiesce,
again, you are casting aspersion without giving her the benefit of the right of response.
And member for Oropouche West, I will remind you that this announcement comes as a response to a letter written by the honourable member, which is widely circulated. To acquiesce...
Yes, ma'am, but your language...
To acquiesce to any of the overtures contained in the letter...
Madam Speaker, you were written a communication by the Leader of the Opposition. Do you not see it fit to respond in a similar mode of communication by letter to each?
And member for Caroni Central, in a way, I would want to excuse the question that you've just asked on your novelty here, but this is very usual procedure. To acquiesce to any of the overtures contained in the letter penned by the Leader of the Opposition would, in my respectful opinion, amount to an affront of the Constitution of the Republic of Trinidad and Tobago.
For the opposition members to be muted, because every time we attempt to stand up and speak, the mics are being switched off, and you, as the guardian of this House, I am seeking your clarification whether you have given a directive to silence the opposition.
Member for St. Augustine, I take it because you're on my left, you are a member of the opposition, and I think we all just heard you speak.
My mic is being cut off, Madam Speaker.
Member, may I proceed? To acquiesce to any of the overtures contained in the letter penned by the
Madam Speaker, if I may, it is only right that the letter of the Leader of the Opposition be read onto the Hansard records of the Parliament, so that those will understand what you are receiving. It is unfair that the Leader of the Opposition has not been given an opportunity to respond to your announcement but yet her letter is not being able to be read into the record of the Parliament.
Member for Barataria San Juan, I believe before serving in this honorable chamber, you would have served in the other place. And therefore, the standing orders in both places are quite similar. And therefore, as you quite rightly know, under the item of announcements, what you are seeking is not the practice, it is not the procedure, and it's not allowed.
Madam Speaker, I cannot serve before, but I also serve as an attorney at law in this country and as an officer. Madam Speaker, I would ensure that there is fairness, justice, and equity in the Parliament. And
I cannot and will not assume upon myself the power to construe the words of the Constitution in a way which is inconsistent with its clear intention, simply to appease the competing interests of those involved. And I so rule.
Madam Speaker.
Member for Siparia be allowed to respond.
Madam Speaker, response to my letter, which you have placed on the record of the Hansard.
Member
is a death announcement, death for the democracy of.
Member for Siparia. Member for Siparia.
The jurisdiction of the
Member for
sitting.
Siparia, would you take your seat?
Therefore, I seek your clarification as to whether I will be able to respond to your
May we proceed, Clerk?
Madam Chair, having sat here and Madam Speaker, having sat here and listened to the announcement that made, I would like to ask if you are aware that May Parliamentary Practice 24 provides guidance on a substantive motion and on a motion which has been brought, it should be rated according to the guidelines provided.
Madam Speaker, you have and you responded to the leader of the opposition.
Member for Couva North and member for Chaguanas East. The announcement has been made, which has provided, I hope, the requisite clarification and guidance.
Madam Speaker, can you advise if May's parliamentary practice still governs this House?
Madam Speaker,
still guides?
Madam Speaker, what was read there is not an announcement. It's a statement by the Speaker. And if the standard orders are to be...
Can we proceed?
Madam Speaker, please.
Motion
Madam
pursuant to Section 36 of the Constitution.
Madam Speaker, by yourself.
Member for Caroni Central. Member for Caroni Central. Please, member for Caroni Central, please take your seat.
Madam Speaker.
Honourable members, on Thursday, October 14, 2021, the Leader of the Opposition and member for Siparia filed a motion with the Office of the Speaker pursuant to Section 36(1)(a) of the Constitution of the Republic of Trinidad and Tobago. Section 36(1)(a) states, the President shall be removed from office where a motion that his removal from office should be investigated by a tribunal is proposed in the House of Representatives. I now call upon the member for Siparia to propose the motion pursuant to Section 36(1)(a). Leader of the Opposition and member for Siparia.
Madam Speaker, just for clarification, you have announced that the Leader of Opposition would be allowed to read her motion. Can you indicate to us if we will have a debate and explanation as we have been asking all morning.
Member for St. Augustine, again, you are another seasoned parliamentarian. I haven't recognized you. I've called on the member for Superior. The guidelines which have been circulated since Tuesday are quite clear, and the announcement was intended to give the clarification which you seek. Member for Superior.
Thank you, Madam Speaker, for this opportunity to participate in these Section 36 proceedings under the guidelines unilaterally formulated by your good self.
Member.
Unilateral.
These guidelines seem to have forgotten the origin of the word parliament.
Member.
They come from the word
Member. Member, I'm on my legs.
Why are we muting the leader of the opposition microphone?
Member for Superior. Member for Superior, would you kindly propose your motion in the text of your motion?
Well, if you put my mic on, I will continue so to do. Is this mic now on? Thank you very much, madam. I'm saying these guidelines done by your good self forgets the word parliament, comes from the word parler, to allow for debate. And before I read the motion, I want to say these guidelines are illegal, null and void. Illegal. Illegal. We participate in these proceedings, the opposition participates in these proceedings under protest. I want to make that very clear. The Section 36 motion, madam, reading the procedure that you have provided to us, again unilaterally, I will turn to it now. And I read that motion. Whereas Section 35 of the Constitution provides that the President may be removed under Section 36 from office where she, A, willfully violates any provision of the Constitution, and or B, behaves in such a way as to bring her office into hatred, ridicule, or contempt. And or C, behaves in a way that endangers the security of the state. And whereas there have been unrefuted reports, A, of recent events at President's House, of interference in the selection processes undertaken by the Police Service Commission. And B, that a list of nominees for the Commissioner of Police prepared by the Police Service Commission was recently submitted to the President, and the President refused to notify the House of these nominees. And whereas the President has neglected to publicly address those reports and has otherwise failed to faithfully execute her several duties under the Constitution. And whereas, in the circumstances, the President should be removed from office since she A, willfully violated the provisions of the Constitution securing the independence of the Police Service Commission in the performance of its functions, and also willfully violated Section 123 of the Constitution. B, behaved in such a way as to bring her office into hatred, ridicule, or contempt, and/or facilitating interference with the Police Service Commission. And also by proceeding in the circumstances to appoint new members of this Police Service Commission. C, behaved in a way that has resulted in the endangerment of the security of the state through her inactions and failure and/or neglect to act. And D has otherwise failed and/or neglected to execute her duties under the Constitution. Be it now resolved that pursuant to Section 36 of the Constitution, a tribunal be established to investigate the removal of Her Excellency Paula May Weeks, ORTT, from the office of the President. Madam Speaker, I thank you, and I just want to raise under Section 2.
Honorable members, Section 36, 1B of the Constitution states, B, the motion states...
Madam Speaker, why are you muting the leader?
Is it an attempt to silence the opposition?
Is the leader of opposition being muted?
Madam Speaker, is democracy dead in this parliament?
It appears that
Madam Speaker, why are you muting the opposition leader?
Today, that members forget that they are in the House of the Representatives. When they speak,
that is why we have to stand up here and represent the chair.
Mr. Speaker, that is why we...
Madam, the people voted for us. Who voted for you?
The motion having been read.
Madam Speaker, the leader has not completed.
Not proposing at this point in time.
Madam Speaker, no fair-minded person could say that the leader of the opposition was allowed to complete her motion. And we demand
an announcement too from high end.
Given the opportunity in this parliament to read her motion.
Honorable members, Section 36, 1B of the Constitution states, the motion states with full particulars the grounds on which his removal from office is proposed, and is signed by not less than 1/3 of the total membership of the House of Representatives. Therefore, in order to move to the next stage, this motion requires not
Madam
less than
Speaker, the leader of opposition has not completed the reading of her motion.
Therefore, in order to move to the next
Madam
stage,
Speaker, in order to move to the next stage, the Leader of Opposition must complete reading her motion.
And member for St. Augustine, I will not continue to tolerate this. We are moving on to the next stage.
But
Madam Speaker, I don't want to continue to tolerate the leader not being allowed. There is a procedure that includes the member reading the motion. The reading of the motion, and whoever cutting off the mic, preventing the voices of elected people from being heard. Madam Speaker, the procedure requires the Leader of Opposition, the member who brought the motion, to read the motion before the next stage is taken. The Leader of Opposition clearly has not completed the reading of her motion. And in order for the voice of the people to be heard, the Leader must complete the reading of her motion. For anything otherwise to happen, it is a suppression of democracy and a prevention of the voice of the people from being heard.
Honourable members, in accordance with the guidelines which have been established, we shall proceed.
Madam Speaker, your own guidelines indicate that in the procedure, the member shall read the motion and then we go to the next stage. The Leader of Opposition has not completed the reading of the motion. So I am asking you to allow the motion to be read in accordance with your own guidelines before we proceed further.
The motion having been read as proposed.
Madam Speaker, I raised an issue earlier which you did not address. I pointed you to May's parliamentary practice, which provide guidelines for substantive motion, and I want to refer you to page 396. Your guidelines is not in harmony with what is provided here with respect to substantive motion. And I'm asking you, can you kindly respond if it is that we are still guided by these parliamentary practice, or you unilaterally will decide how this...
Member for Couva North, my guidelines are in accordance with the Constitution and the Electoral College regulations.
But it's illegal.
Member, I have rules. I'm not taking conversation from you sitting. Therefore, in order to move to the next stage, this motion requires not less than 1/3 of the total membership of the House of Representatives. The clerk will now call the names of the members who signed the motion. Clerk?
Mrs. Kamla Prasad Bisesa, SC, Leader of the Opposition and Member for Siparia.
What motion? We didn't hear the full motion.
Mr. Saddam Hussain, MP.
What motion? We did not hear the full motion by the member for Siparia.
We heard a
Member for Siparia.
What
Member
am
for Barataria, Samu.
Madam, I say no to this entire illegal process.
Mr. Arnold Ram, MP. Member for
I
Caroli
did not
Central.
get a chance to respond.
Mr. Dinesh Rambali,
I support
MP.
the motion.
Member for Chaguanas West. Mr. Ravi Rataram, MP. Member for Couva North.
What are you asking?
Indar Singh, MP. Member for Couva South.
Madam Speaker, I support the motion and I disagree very strongly with the no debate guidelines in this House.
Dr. Rai Ragbir, MP.
I support the motion and I disagree with the no debate guidelines. Thank you.
Madam Speaker, we are yet to hear the full motion.
What it is you call an...
What did you call? Member for Hyderabad.
I support the motion, but I disagree with the no debate guidelines.
Member for Naparima.
I fundamentally disagree with the no debate guidelines, but I confirm my support for the motion.
Dr. Rudal Munilal, MP. Member for Hurapuchi. Mr. Narendra, MP.
This is a suppression of democracy.
West. Dr. Rashad Sicharan MP, member for Caroni East.
Madam Speaker,
Ms.
I
Dana
support this
Mohit,
motion, but I
MP.
disagree with the no debate guidelines.
Member for Chaguanas. Dr. David Lee. Mr. David
Madam
Lee,
Speaker, I
MP.
support this motion, but I do not agree with this no debate motion.
Member for Point-a-Pierre. Mr. Barry Padarat, MP, member for Princess Town. Mr. Michelle Benjamin.
And have done the bidding of the PNM in this house today.
Madam Speaker, may the record reflect that I support this motion, but this is a debt to our democracy, what you are doing here at this point in time.
Mr. Michelle.
Madam Speaker, I was also not allowed the opportunity to comment,
Ms.
although my
Michelle
name was...
Benjamin, MP, member for
I think that is a breach of parliamentary
Speaker, I support
process.
this motion, but I disagree with the process.
Ms. Khadija Amin.
Madam Speaker, my name was called out, but I was not allowed the opportunity to speak, to comment. I think that is a breach of process. Just for the record, Madam Speaker,
Ms. Khadija Amin, MP.
I completely
Madam
support the leader's presentation and the
Madam
leader's
Speaker,
motion.
I stand firm against
The abuse
the
of process.
suppression of democracy. I want the opportunity to be debate and be the voice of the people who elected me.
Ms. Anita Haynes, MP, member for Tabaki.
I confirm my
Mr.
signature,
Rushton
and
Parry,
we
MP.
deserve the right to debate in this house, Madam Speaker.
Madam Speaker, could we have some decency in terms of how this process is being conducted this morning? Madam Speaker, this house has been hijacked. You are seeking confirmation of members, and this process, like if we are 100 meters race now.
Madam Speaker, I did not even...
Where in the Constitution says
I confirm my signature.
Member for Chaguanas East, could you kindly keep a seat? Take a seat. Your name was called. You confirmed your signature. Honorable members, Section 36(1)(c) of the Constitution states C. The motion is adopted by the vote of not less than 2/3 of the total membership of the Senate and the House of
Madam
Representatives.
Speaker, we again
assembled
register
together.
our protest at the travesty of the parliamentary democracy.
Honorable members,
Madam
Senate
Speaker, the
and
leak
House-
in the Red House has apparently...
Honorable members, the Senate and the House of Representatives assembled together is a unicameral body called the Electoral College. Once the required majority, 2/3 vote is obtained from the Electoral College.
Madam
The
Speaker, could you
Constitution-
what they are going to vote on? The motion has not been completely read by the leader of opposition and the member for Superior.
Member for St. Augustine, we are continuing with the procedure. You seem to have forgotten that you stand when you are recognized. And remember, you were the one complaining about the mics. I hear you very well. There is no
Because
need.
I'm overriding the system, Madam
There is
Speaker.
no need to shout. There is no need to shout. There's no system to be overridden. We are hearing you very well. Once the required majority.
Electoral College as well. So would this be read out before the Electoral College as well, just for clarity?
Once the required majority, 2/3 vote is obtained from the Electoral College, the Constitution states that D, a tribunal consisting of the Chief Justice and 4 other judges appointed by him, being as far as practicable the most senior judges, investigate the complaint and report on the facts to the House of Representatives. Thereafter, the Constitution states that the Electoral College...
Madam Speaker,
on the
could
summons
you
of the
clarify,
Speaker,
based on the inquiry of the member for Oropouche East, whether the member for Superior will be allowed to read the motion to its completion when both houses meet? Because those members, neither the members here, to hear
kindly
the
have a
motion.
seat. Thereafter, the Constitution states that the Electoral
Madam
College,
Speaker,
on the
Madam
summons
Speaker.
of the Speaker,
Madam Speaker.
Member for Chaguanas West, Member for Chaguanas West, kindly have a seat. Member for Chaguanas West, I have asked you. I'm going to ask you again. I am going to ask you again to take your seat. And, you know, members, the member for Couva South asked that we proceed in an orderly fashion. Therefore,
Madam Speaker, respectfully, I want to confirm my signature in support of the motion.
Member for Chaguanas West, please have a seat. Member for Chaguanas West, have a seat. That item has have a seat. That item has already passed.
I am simply saying, with the greatest of respect, the clerk of the House cannot confirm my signature for me.
Kindly have a seat. Can you have a seat?
Why is the member for Chaguanas West?
Member for
not
Chaguanas West, have a seat. Therefore, the Constitution states that the Electoral College, on the summons of the Speaker, will consider the report of the tribunal and by resolution supported by the votes of not less than 2/3 of the total membership, declare that the President shall be removed from office. Therefore, honorable members, in accordance with Section 36(1)(c) of the Constitution of the Republic of Trinidad and Tobago, this motion proposed in the House of Representatives requires a vote of the total membership of the Electoral College. Accordingly, I have summoned the Electoral College for this purpose. Honorable members, you are reminded.
Madam Speaker,
will never hear the motion.
My colleagues have been continuously seeking clarification from you in relation to whether this motion put before by Member for Superior.
Member for Couva South, resume your seat.
Simple.
Resume.
Today, what is behind? What is attended? What it is to be hidden in terms of you continuously are telling the country, the citizens of the country are looking on. Well, we want to be in a very comfortable place too, in terms of transparency and accountability here.
Honorable members, you are reminded that this House stands adjourned to a date to be fixed.